Thank you, counsel.
May it please the court, my name is Stephanie Cook, and I represent the appellant in this case, Lisa Renee. I'd like to reserve 3 minutes for rebuttal. Lisa Renee is the granddaughter of Lily S. White, Miss White, and was the nominated successor trustee of the Lily S. White Revocable Trust Agreement dated February 23, 2006, which I'll refer to as the 2006 trust. Miss White is an 85-year-old woman who unfortunately suffers from paranoia and dementia and is easily influenced, according to the examining committee reports. Miss White had several siblings, all who passed away with the exception of Janie Sykes Kennedy. Miss Kennedy has a daughter named Sheila Bryant. The beneficiaries of the 2006 trust are my client, Miss Renee, and her 2 children, Nathan and Gabriella. After a step-nephew of Miss White became concerned about Miss White's condition, she was found basically wandering outside her home. He went and picked her up, and Miss White came to live with him temporarily. His concerns began to grow, and he communicated those to my client about a condo that had gone into foreclosure because Miss White had not paid the condo fees. Mr. Ford filed a petition to determine incapacity and to have a guardian appointed. During the pendency of the incapacity proceedings, Miss Kennedy's daughter, Miss Bryant, moved from New York, moved down and moved in with Miss White in her house in Palm Coast. In between 2 sets of examining committee reports, all which came back that Miss White needed a plenary guardianship, Miss Kennedy's daughter, Miss Bryant, drove Miss White to an attorney's office to execute a 2012 trust. The 2012 trust in December of 2012 was identical to the 2006 trust, with the exception that the trustees on the new trust were the proposed guardian, Miss Kennedy, and her daughter, and they were the sole beneficiaries. They had never been a part of Miss White's estate plan in the past that we're aware of, certainly not in the two.
It was not ever funded, correct?
It was never funded, and it does not revoke the 2006 trust. At the hearing, ultimately, over my client's objection, Ms. Kennedy was appointed guardian. Those proceedings were declared adversarial by Ms. Kennedy during the initial pending guardianship petitions. My client, after becoming concerned about her grandmother, she accepted the trusteeship. She was the named successor trustee, notified financial institutions, and then in her petition to also have a guardian appointed, which she filed as well, she notified the court, just to make sure there was no conflict of interest, that she was also trustee, which she had an obligation to do. However, she only appeared in the guardianship proceedings as an interested person as next of kin. After being appointed guardian over my client's objection, the guardian moved under Florida statute section 744-441, 2 and 19 to become the trustee. There were no allegations of wrongdoing. In fact, the court order ultimately appointing the guardian as the new successor trustee even states that there were no findings of wrongdoing presented at the hearing. In response to the petition for the guardian to be appointed trustee, my client objected, saying the court didn't have jurisdiction over the trust, that the Florida Trust Code 736-0201 requires that a separate trust proceeding be instituted if you're going to remove a trustee, and that section 744-441 didn't allow this based on the powers delegated to the guardian. This was a limited guardianship, not a plenary guardianship, which becomes important when you're looking at the statute.
There was a hearing held on the motion?
There was a hearing held on the...
Did your client appear?
No, she did not, nor she...
Didn't raise any of those objections at the hearing?
Yes, Your Honor, in the objection that she filed and at the hearing, it was raised that she didn't believe the court had jurisdiction. It was a proper petition because of all the reasons stated in her motion. And at that hearing, over the objection I expressed on behalf of my client, let me back up. The beneficiaries, who are my client and her 2 children, were not given notice of the proceedings.
What notice? I thought they knew about it and raised objections.
They were not.
They were represented by their lawyer?
Not at the hearing. They were not represented at that time. They got representation after the hearing on the appointment of the guardian as successor trustee. The
objections that they raised were raised before or after the hearing?
They raised objections after the hearing saying that they were interested parties, which the court did recognize in a subsequent order, and that they should have been given notice and an opportunity to be heard.
You're talking about the two great-grandchildren.
Correct.
But as to your client, their mother had an attorney who had filed a petition and had received notice of the hearing. I mean,
Correct.
your client had already had filed a petition to be appointed guardian, so.
Correct, as next of kin. The important distinction here is the trust code requires that there be a separate petition filed and that it's governed by the Florida Rules of Civil Procedure.
Okay, but go ahead.
Does your notice argument fail if a separate notice or a separate petition is not required?
I believe even if a separate petition isn't required, that formal notice under the probate code would be required because it's an adversary proceeding, notice to all interested parties, which would include the beneficiaries and the trustee, and then they would have 20 days to file a response. I think it's important, again, that the trust code, if you look at, this cases interpreted 744-441 have not addressed the argument of a separate trust proceeding, but it has been addressed in the context of an estate proceeding.
But your argument in your brief is she didn't have an opportunity to be heard. Didn't she have an opportunity to be heard if she had come to the hearing that she chose not to come to?
She chose not to come. She did not want to waive any sort of jurisdictional argument and say, okay, you're here now.
Wasn't that her opportunity to be heard? If the complaint is a due process argument, she didn't have an opportunity to be heard. Didn't she have an opportunity to be heard by coming to that hearing?
Well, Your Honor, again, she did not appear because didn't want to waive. If the court doesn't have jurisdiction, the order's void. If there's no jurisdiction over her, if she's not properly served, which she wasn't, she appeared in the guardianship as next to kin, not as trustee, not as beneficiary of the trust. If this ruling...
Didn't she, before the hearing, hadn't she filed a petition to be appointed guardian?
She had as next of kin, she never appeared in the context of trustee and beneficiary of the trust. And again, the trust code says very clearly there has to be a separate trust proceeding. And again, even 744-41, when you look at the plain language of that statute, which again is petition for authorization to act, a guardian can file a petition to act, but in the context of a limited guardianship, it's only within the powers delegated to the guardian. In this case, there was no delegation to the guardian to amend the trust, to make dispositions or gifts of property, which can be done under the trust agreement now. I think it really leaves open exploitation of vulnerable adults when a guardian who's never been part of an estate plan, who's been estranged for about 15 years from her sister, can come in, get appointed guardian, show no grounds for removal, and come in and get themselves appointed trustee. I mean, trusts are often done so you can plan for your incapacity. And Ms. White did that in 2006. She said, if I'm incapacitated, I would like Ms. Renee to be my successor trustee. And again, with no grounds for removal and no separate trust proceeding, but even if we just look at best interest, which is what has been addressed in the context of the cases interpreting 744-441, for example, this court heard the case of Reddick v. SunTrust. And in that case, the wife of the now incapacitated person filed a petition to become guardian and replace SunTrust Bank as trustee. And this court looked at the fact that the now incapacitated person's desires had been clearly expressed in the trust document, and that there was no finding of wrongdoing on the part of SunTrust, so therefore it would not be in the best interest of her incapacitated husband to come in and substitute the corporate trustee that had been selected by the person when their capacity was not in question.
Let me ask you this. If we accept your arguments, does that trust in essence become an irrevocable trust?
Well, the trust code says that the capacity required to amend a trust is the same as to make a will. So in some sense, it becomes irrevocable. When the person is incapacitated, then they cannot amend the trust, certainly for purely personal rights. It's clear the purpose of 744-441 was, in the context of subsection 2, was to allow the court to aid guardians within the order appointing them in doing their job, and a limited guardianship only in those powers articulated in the order. Subsection 19 specifically states that the court can authorize the amendment or the creation or revocation of a trust for estate planning purposes. There was no estate planning purpose alleged or in...
But if your arguments are correct, doesn't it make it irrevocable, though? I mean, you can't change your trust. I mean, the court can change your trust if there's misconduct by your client as trustee, but it seems to me under your argument, you're saying that that trust can't be amended or revoked in any way. Once she became incapacitated, we're stuck with the 2006 trust no matter what.
Well, I believe it would be, I think the answer is yes and no, in that for certainly if she regained capacity, then she could revoke it then.
Assuming she can't regain
Okay,
capacity.
then I think if unless 744-441 authorized the guardian to act in this situation, then I guess it could be seen as irrevocable. What I'm saying is, let's say there was an estate planning tax purpose for this, then I think that the court could have considered doing that under subsection 19. I think under these facts, it may become irrevocable if she never regains capacity, but I don't know that I want to go quite that far, because I think if there had been a proper separate removal proceeding, or if there had been a tax purpose for this, then maybe things are a little different. But that's not what happened in this case.
So you're saying section 19, which says a guardian with the court's approval can amend a revocable trust, only applies if it's some technical thing. Is that what you're arguing?
Not necessarily
Like a
technical.
tax benefit or?
Well, I think that we should look at what the incapacitated person wanted prior to capacity, and yes, I don't think that the court should be allowing a guardian to change what's in that trust unless it's absolutely necessary, and one of those reasons would be for some tax purpose or estate planning purposes as articulated in that subsection. I think that we should be very careful here. I think that that's why the trust states, if I'm incapacitated, here's who I want in charge, and that's a lot of the reason that people do trust, is so if they are incapacitated, their assets stay out of guardianship and protected.
So it's not a best interest standard, it's some higher standard, absolute necessity?
To do what? To remove a trustee?
No, to change the trust. You said that if there's a guardian there, they should only be able to change the trust if it's absolutely necessary.
No.
The normal standard is what's in the best interest of the ward. If it's in the best interest of the ward to change the trust, can a guardian with court approval change the trust?
It is a best interest standard. I think I was articulating a public policy argument if we want to be very careful here with going in when someone's incapacitated and allowing a guardian to come in and make decisions personal to the ward or otherwise. I think the interplay between the trust code and the guardianship statute is very important. I think it is important that the cases cited under 744-441, there wasn't a separate removal statute or provision in the trust code. The trust code says if a proceeding regarding a trust shall be commenced by filing a petition, and it operates under the Florida Rules of Civil Procedure. My position is that in this case, to remove a trustee when there's no wrongdoing, no allegation of wrongdoing, that there had to be a separate trust proceeding. But even if this court doesn't agree with me on that, it still is not in Ms. White's best interest to ignore her wishes that were expressed long ago when capacity wasn't in question, when her intent was clear, and again, when there's no showing of wrongdoing, just that the incapacitated person now, who's been living with the guardian's daughter, and my client has been able to have contact, now wants somebody brand new to be trustee. I just think that leaves the door open for exploitation. I think that it's, again, the reason oftentimes people create this a trust is to protect themselves in incapacity. And it has been addressed, the separate trust action, in the context of estate proceedings. Again, for example, in the estate of Black, a nephew filed an objection to the probating of a will of the decedent's husband, and wanted to remove him in that proceeding as trustee of a trust. And he served it by formal notice. And the court in that case said, okay, well, you gain jurisdiction over the person, over him as PR, but not as trustee. The trust code's clear. You have to file a separate proceeding. And where the best interest comes in, the best interest standard comes in, is in order for the guardian to file a separate trust action, they seek court approval and show the guardianship court that it's in the ward's best interest to file that separate trust proceeding. So best interest is certainly part of the analysis, but here, the procedures were skipped over. And again, I think it's important that the trust beneficiaries, particularly the two grandchildren, were not given proper notice and opportunity to be heard. This, the filing a separate trust action was also addressed in Barley versus Barkus, which is the 5th ECA case, and in that case, this court defined an interested person under the probate code, which is anyone who's reasonably affected by the outcome of the proceedings. Certainly, these qualified beneficiaries would be reasonably affected by substituting in a brand-new trustee that's not named in the trust.
Grandchildren are minors, is that correct?
That is correct.
So how is notice properly given to them?
I suppose that they would have to serve the parent or the guardian.
So notice to the parent would become notice to the minors.
If the parent was given proper notice, and proper notice wouldn't be simply serving the parent's attorney in a guardianship proceeding in which that parent has only appeared as next of kin, not as trustee, not as beneficiary. So I think that's where the argument that she can step in their shoes, that may be true if she's properly noticed to begin with, and that didn't happen in this case.
Does that argument solve anything? I mean, if we say that lack of notice, and then they send, they say, send you a notice, and it goes back, and the notice is not just as next of kin, but as named trustee or named successor trustee, are we going to be back here a couple months later on the exact same arguments?
No, I think if notice was improper, then the order is void for substituting the guardian as trustee, and they can seek guardianship court approval and show it's in Ms. White's best interest to file a removal action and try and remove my client as trustee, or even if you go under 744-441, they still have to serve the beneficiaries.
Let me ask you this. Now, your client's attorney was present, made various arguments. Was lack of notice raised?
Yes, it was raised, and I was the attorney. It was raised in the motion to strike, which was basically our objection to their petition that was filed to substitute the guardian as trustee. And then I referred to what I had filed in front of the court and told the court that these were legal arguments, that we made the jurisdictional arguments, and that that's why my client wasn't appearing, because she wasn't going to appear, and then they hand her a subpoena, or they say, well, you're here now, you've submitted to the court's jurisdiction. So I did. I don't know that I articulated everything in my written objection that was filed, but I certainly raised the issues.
You're down to about 2.5 minutes if you want to save it for rebuttal.
I would like to. Thank you, Your Honor.
Good morning. May it please the court. My name is Jack Pelzer, here today representing the ward, Dr. Lily Sykes White. I would like to thank the court and my colleagues for accommodating my schedule today. The fundamental question that's raised today is whether or not the trial court was correct in following the established procedures for a guardian to seek approval to amend a ward's revocable trust. And I would say to you that the suggestion in the reply brief that this is a case of first impression is inaccurate. This is actually a very well-trod path, a very well-established procedure. This is simply the first time someone has made this argument. That doesn't make it a case of first impression. This procedure has been well-established in the jurisprudence in Florida for some time.
Let me ask you this. On the best interest test, should we be concerned about the attempt to create a 2012 trust?
No, Your Honor, that's a complete red herring. And in fact, on this...
Well, it happened, right?
Oh, certainly it happened. There's no doubt about that.
It indicated an intent to change the beneficiaries and to change where the money would ultimately go, right?
It indicated Dr. White's intent. All the evidence that's in this case...
Well, Dr. White, there had already been a committee that determined that she was incapable of making that decision.
There had been the committee reports that was in between the committee reports and before the adjudication.
But so you have a committee report that said she's incapable of making this decision, and yet someone takes her to an attorney's office to create a trust? I mean, should we be, like I said, should we be concerned about that in determining whether it is in the best interest of the ward to appoint your client as a guardian if your client was part of this decision to bring her to an attorney to create a new trust after a committee had already determined she was incompetent to do so.
You said if, and that's a great big if, Your Honor, because here we need to separate the supposition and innuendo.
I said if.
And because...
I don't think the trial judge made a finding one way or
The
another.
trial judge did not make a finding, but the only evidence that's in the record is that this was Dr. White's decision, that Ms. Bryant merely gave her a ride to her then attorney's office, that Dr. White spent approximately a week going back and forth with her attorney, with Mrs. Bryant not in the room, discussing this, and then she finally executed this document, which frankly was, I can't imagine why it took a week, because all the lawyer did was copy the 2006 trust and change a few names, but apparently he's not a trust attorney, didn't know what was necessary there. But the 2012 trust, simply was never funded, and is, in that respect, I say to Your Honor, is a red herring. At this point, there has been no effort made by the guardian, Mrs. Kennedy, to request court permission or to do anything to alter the plan of devise, and in fact that was stipulated at the hearing to appoint Mrs. Kennedy as the trustee under the trust, was that this was not being done for the sake of changing any of the distribution aspects of the trust.
Counsel,
And so,
let me ask this. 736-0201 provides, except as provided in subsections 5 and 6 and 736-0206, judicial proceedings concerning trust shall be commenced by filing a complaint and shall be governed by the rules of civil procedure. Why doesn't that provision mandate that there be a separate proceeding? And part of what it goes on to say that judicial proceedings involving trust may relate to the validity, administration, or distribution of the trust, including proceedings related to, and then it has a bunch of stuff, one of which is appoint or remove a trustee. So if you're trying to appoint a trustee other than the trustee named in the trust instrument itself, and you agree that there was apparently a successor trustee named in the trust instrument.
yes, there was, Your Honor.
Okay. So, I mean, the practical effect is you're removing the successor trustee and appointing a different one. Isn't that correct?
That's the effect of the amendment, yes.
So why doesn't, and you would agree with me that trusts in general are administered outside the jurisdiction of the court?
Normally, especially a revocable trust, yes.
Well, any trust,
Right.
But you can invoke the jurisdiction of the court by filing a proceeding under 736-0201. I mean, that's the way I always understood that we did it, was we invoked the jurisdiction because we had something to do that wasn't contemplated, or something that might be contrary to the terms of the trust or whatever. So I guess what I'm trying to get at is you've got this guardianship proceeding going on over here, and we've determined that Dr. White is incapacitated, but you've got this trust over here that has a provision for a successor trustee in the event of incapacitation. And so what I'm trying to figure out is how you get from this guardianship over into the trust without filing a separate proceeding as required by statute.
There are two important points there, Your Honor. One is statutory, and the other just has to do with the nature of revocable trust. I want to go to the second part first, but I want to come back to the statutory point because that's just as critical. You say we have the guardianship proceeding here, and we have the trust over here. That is, I would submit, inaccurate. This is a revocable trust that is revocable by Dr. White so long as she is alive. That is what Article 6 of the trust states. So long as she is alive. Not so long as she has capacity, but so long as she is alive.
Well,
this
you would
trust is
agree
her
that
personal property.
But the law would require that, and I haven't, I'll have to look at the trust. I'm assuming if this is sort of the generic trust agreement, that it provides that the appointment of a successor trustee in the event that Dr. White is incapacitated or unable to administer or resigns or something like that. Some general language about that.
There is that general language, yes, Your Honor.
Okay, so you know, you've got this language in there that, I agree with you that the irrevocable trust is property of, arguably property of the guardianship estate. but that doesn't, I'm not so sure that that necessarily says that the guardianship court has the jurisdiction to sort of run roughshod over the administration of the trust. I don't know. I mean, it's an interesting question about how you get the two of them to play in the sandbox nicely.
Actually, and this is the statutory point that I wanted to get to, because the legislature has provided that point of interface. There is a more specific statute than the 0201, and this is 736.0602 subsection 6, which specifically...
02?
736.0602 subsection 6. And what that section provides is, in this factual context, when you have a revocable trust that is the property of a ward in a guardianship proceeding, then the trust code defers to the provisions of the guardianship chapter, which is 774.441, and it does so by specific reference to that section, 744.441, and subsection 2, which gives the guardianship court the power to make these, or to grant a petition on the part of the guardian to make these kinds of amendments to trusts. And that is the well-trod procedure, the well-trod path of the Mueller case, the First National versus First Federal case, the ALR article that we cited in our brief, the Bogerts on trust provision that we cited in our brief, the Florida practice manual, and in fact, even the cases that Ms. Renee relied upon, they finally concede in the reply brief, followed the exact same procedure. They simply proceeded pursuant to 744.441. And the only argument here is that every judge and every lawyer in those cases just must have been ignorant and didn't understand the law. But this is the well-trod path. And again, why I say it's not a matter of first impression, it's merely, the first time someone has made the argument that 744.441 doesn't mean exactly what it says. And that this dovetail, the interplay that is at 736.0602.6 doesn't mean exactly what it says. This is the first time somebody's argued it. Doesn't make it a case of first impression. This is actually a very well-established area of the law. And again, the reason for that is because the trust is the property, not of the trustee, but of the trustor, in this case, who has the right to revoke it at any time, so long as she is alive. While she is subject to incapacity proceedings, we have to use the procedures of 744.441 and get permission of the guardianship court. But that doesn't mean that the trustor, the settlor, Dr. White in this instance, has in any way lost any of her rights with respect to this trust. It's her property. And as I say, it does not make this trust from a irrevocable trust into an irrevocable trust merely because of incapacity.
So the decision rather to change the trustee was to totally eliminate the trust.
Theoretically, that could be done if...
Guardianship?
In the guardianship, if the guardian and the guardianship court concluded that it was in the ward's best interest, yes.
There'd be no need for an independent trust action.
That's correct. Now, certainly...
Are you required to give notice to people who would be affected by that decision?
That's right, yes, because that's the way the guardianship chapter works, is you're required to give notice to interested persons, and Ms. Renee here did have notice, and she appeared through counsel at the hearing. And so, in that respect, that notice argument, I think, falls by the wayside. It was not necessary to do some initial service of process and send a summons up to Maryland to Ms. Renee's home in order to get jurisdiction over the trust. The trust was already part of the guardianship estate because it's part of the property of the ward.
Let me ask you this. You said it might be in the best interest to revoke a trust, and you said it can be done under, I guess, Section 19. Mm-hmm. For instance, maybe it costs more money to operate the trust than was in the trust. That would be an example. Do you think a trial court can determine the best interests of who beneficiaries are?
Well, the guardianship court is to be determining the best interests of the ward, not the best interests of the ward's beneficiaries.
Right, but in applying a best interest test, can a guardianship court determine who would be what's the best interest of the ward as to who the beneficiaries are?
To change the plan of devise.
That no court can determine the best interest. That's strictly, settler's intent.
And it may be We don't have that situation here. No one's asked the court to change.
I'm kind of getting a feeling that this argument here may be a precursor to...
And it certainly is a possibility, Your Honor, that if Dr. White instructs the guardian that she wants to change her plan of devise, that there may be a petition to do that. When that is done, if it is done, it will be done fully, openly, and legally, and it won't be done as a result of any kind of secrecy. It can't be done with any kind of secrecy because we have the guardianship proceeding in place. If, as my colleague concedes, there's the possibility of Dr. White regaining capacity or even having a temporary moment of lucidity, which is another point that is frequently considered in guardianship cases, that may occur. And certainly, as my colleague has pointed out, this is a limited guardianship. Dr. White retained two primary rights. One was the right to vote, and the other was to decide who she should socialize with, who her friends are. She still has that right under the limited guardianship. We don't know how that's going to play out. Now, as I wanted to point out, the only argument that counsel makes to distinguish In re Muller, which is the case that established this proposition that 744.441 is the correct procedure to follow. The only distinction that was made there is that Muller was a plenary guardianship while ours is a limited guardianship. And I said that is a difference without a distinction because the guardian in this case is a full guardian of the property. And 736.0602 subsection 6 specifically references guardian of the property being permitted to use the procedures of 744.441. And so there is no limitation on the guardian's authority in this instance to act with respect to the property of the ward, which includes in this instance the revocable trust. There have been, I think we've discussed a few of them, some of the I would say speculations, innuendos, accusations that have been unproven but still leveled at the guardian in this case. Of course, I'm here representing the ward, not the guardian, but those, it must be pointed out to the court that those points are simply without evidence in the record. And this gets back to the suggestion about the 2012 trust and why I said it was a red herring. It's a red herring because there's simply no proof of the suppositions and accusations, and the evidence is to the contrary. And we heard the word here today, estranged, that the guardian was somehow estranged from my client. There's absolutely no evidence whatsoever of that in the record, that no one has ever testified that these two sisters were estranged, certainly during the period of time that the guardian was caring as the guardian for her husband while he went through dementia. That was a period of time when the two of them didn't physically get together as often, but there is no suggestion of any estrangement whatsoever. The argument that there's some grounds needed for removal of a trustee of a revocable trust is simply anathema to the concept of trust law. A revocable trust is exactly that. It's revocable for a good reason, a bad reason, or no reason at all. The fill-in-the-gaps provisions of the trust code, and my colleague agrees that the trust code is entirely a fill-in-the-gap statute. It only applies when trusts are silent. If a trust says that it's revocable, there's no need to even look at the procedures for removal of a trustee because it's a revocable trust. The trustee can revoke it at any time and recreate an entirely new one with a different trustee or amend it completely at the whim of the trustor. There's no need whatsoever to look to the statute and find grounds for removal, and that's why the trial judge made the findings that there were no bad acts by Ms. Renee in this instance, but still it's in the best interest of the ward, my client, to have Mrs. Kennedy be the guardian and not Ms. Renee. And the reasons for that were expressed by Dr. White herself at the hearing. Dr. White was present at the hearing, was sworn in, testified as a witness, was quizzed not only by counsel for both sides but also by the court, and she expressed her great fear. Her great fear was that Ms. Renee had only a few months earlier filed for bankruptcy. And in Dr. White's words, she was in fear that she'd be in the poorhouse if she allowed Ms. Renee to manage her funds. And add to that the great discourtesy and disrespect that Ms. Renee showed to Dr. White when she unilaterally took over her bank accounts without so much as the courtesy of a telephone call and forced Dr. White to undergo the public humiliation of standing in a bank lobby and being told she had no money. That was certainly a justifiable reason for Dr. White to choose not to have any of her financial affairs governed by Ms. Renee and instead to leave it to the much more seasoned money manager, Mrs. Kennedy. We ask you to affirm.
Thank you, counsel.
Couple of points, Your Honors. Number one, a trust, even a revocable trust, is not part of the guardianship. The trust states that upon her incapacity, my client becomes successor trustee. That is outside the guardianship. Again, one of the reasons estate planning attorneys use this estate planning tool. The cases that were cited in the briefs interpreting 744, 441 are all plenary guardianship cases. It's not a distinction without a difference, or the legislature wouldn't have made a distinction. It certainly matters what powers are granted to the guardian, and in this case, the power to make dispositions of property and gifts, that was taken away from Ms. White and not delegated to the guardian.
Let me ask you this. Opposing counsel argued that the trust code and the guardianship code are linked by section 736.0602 subsection 6, which says a guardian of the property of the settlor may exercise the settlor's powers with respect to revocation, amendment, or distribution of trust property only as provided in section 744.441. What's your response to, in essence, their suggestion that the guardianship code, if you would take precedent over the trust code in this situation?
My response to that is that it refers to 744.441. It doesn't defer to it, refers to it, and then you go to that statute, and you have to follow what's in that statute. And that statute requires for the powers the guardian seeking to exercise in a limited guardianship to have been delegated to them. There's also a section in there.
But that section doesn't mention a separate action.
It doesn't discuss a separate action, and I don't know if there's some sort of gap there in the statute, but what I will tell you is in the guardianship code, which is referred to, as you just mentioned, it talks about filing actions on behalf of the ward and seeking court approval to do that as well. So there's also provisions in the guardianship code that say if you need to file a separate action, which is required for removal of trustee, it doesn't refer to removal of a trustee. That's just essentially what happened here.
That could cover a situation where, say, a trust owns real property, and there's going to be an action brought against the neighbor. So the trustee gets approval from the court to bring an action, to file a separate lawsuit. This is a little different scenario. This is determining who the trustee is.
There's no distinction as far as filing the lawsuits, and here it's to remove a trustee, and I certainly, based on the clear language in the trust code, believe that a separate action needs to be filed. But even if this court doesn't agree with me...
In your case, what does that section mean then? The 736.0602 subsection 6, why even have it in there if you have to have a separate action?
Because I think it's deferring back to the guardianship court and saying that you need to file a petition to get authorization to act, including filing a separate trust action, and the court make a determination in the guardianship that it's in the best interest of the ward. Again, Your Honor...
Your time's expired.
Oh, sorry. Thank you.
Thank you all. The court will be in recess.